outrageous for for prosecution to allege or to assume jurisdiction that this court has jurisdiction to interpret questions which we had raised. Whereas we take recognition of the fact that the Constitution of the Republic of Uganda ushered in this very general court martial to discipline or to handle cases regarding the disciplinary of military. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction to interpret these questions. I would love to implore this court to adopt this decision while the Constitutional Court was faced with the same similar matter in the case of Honorable Sam Kutesa and two others versus Attorney General, which we had prior in the morning while submitting on the same, was submitted by the defense team, that is by Counsel Kalivala. The House of Lords in this case, while elucidating on these facts, we are able to persuasively adopt the decision in Namibian case of State versus Cherison, 1991, volume 20 SA, at page 813. And it was to the effect that the Constitution, this is the catching word, the Constitution of a nation is not simply a statute which mechanically defines the structures of the government and the relationship of the government and the governed. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can ably see what is happening on you. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation, the articulation of the values bounding its people and disciplining its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence. They are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm differing from the view of my land friends. They are trying to hoodwink and mislead this honorable court, which we totally disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that constitutional provisions should, the word is should, not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the grand norm. Article 2, Clause 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the ones which this General Court Martial is citing, if it is inconsistent, it is contrary to the provisions of Article 2, Clause 2. The framers and the promulgation of that very article were alive to the fact that certain issues arising out of during proceedings like similar one might arise. That if any law, if any regulation which is in consistency with that very particular article, it should be declared null and void. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court to disassociate the submission of the prosecution. They have miserably failed at any stake with any iota of evidence to prove their case. I so pray.
Because in my view, they have not dealt with any of the issues that we raised, and I am grateful that they have made our work a little easier. We are past the stage in this country where we should have mechanical responses to legal issues. To just say no because I can say no. I think I should say no because there is value in the position that I have adopted. I have listened carefully to what my land friends have said, and a lot of it sounds to me like the arguments we will invite them to make when we go, hopefully, when we are referred to the Constitutional Court. Because those arguments will be very important in that court as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially that the questions around impartiality have nothing to do with the fine members who are in this court. It's not personal. We have no doubt that the gentlemen and lady officers who are in this court are fine gentlemen. But I said gentlemen and ladies. But the regulations we cited, they are laws, they are not individuals. I appreciate fully the idea that the High Command and the General Court Martial have different roles, administrative and otherwise. But I read a rule which says that the High Command can be consulted on matters of law. I haven't heard, I think it is 69, I haven't heard a response that says it can't. If we take it to the other side where we are used to appearing, there is no similar provision where a judicial officer, also appointed by the president, can consult the appointing authority. It doesn't sit comfortably with the idea of impartiality. So it's an institutional issue, it's not a personal issue. It has nothing to do with the gentlemen before whom and the ladies before whom we are appearing in these proceedings. Honorable Chair and honorable members, we treasure the Constitution, as I am sure you do, because it is the only one that equalizes all of us. It's the only one where everybody can look and say, I am equal to this one, I'm equal to that one, in that document. So we find it uncomfortable when some of these things are trivialized, especially where they have to do with the Constitution. This is not a petition that we are asking to be made, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my land friends to do was to enrich the questions so that we go together and come back together better enriched, knowing where everybody can trade, so that we are not walking on eggshells, nobody is walking on glass, nobody is afraid. That's what I expected, that they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology, because that appears to us to be what must happen when Article 137(5)(b) is invoked. So I would invite the Honorable Court to consider those questions as posed, and perhaps to also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because there is a formal document. It would be presumptuous of us to phrase the questions and then just thrust them in the face of the court. We would have been hoping that we would have agreed together with my land friends so that we focus on what the court will submit. The questions that we posed were our proposals. We thought they covered the necessary ground my brothers on the other side, can enrich them. In fact, I invite them to do so. So that when they are leaving the court, we are in agreement about what those questions are. We are not debating at all the power of the appointing authority. The appointing authority appoints many people. But if an ambassador were appointed and is allowed to exercise judicial power, we would argue the same things that we are arguing today. Although they were appointed by the same. If an RDC attempted to exercise judicial power, also appointed by, we would argue the same things. We are just dealing with matters of rule of law. They affect all of us. They are for the benefit of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly, my land friend Colonel Brigadier Raphael knows that constitutional interpretation is a matter in rem. It's not in persona. It is in rem. Once the court says A, it has said A. Only a superior court can unsay A. We have cited before you a number of authorities where the court which interprets the Constitution has consistently, in fact, in one of the cases, they just said we adopt the other views and we transplant them. Consistent. There is no other interpretation. We have one, only one. And we must abide. If indeed we are subordinate to civilian authority, we must abide by that interpretation until there is another interpretation. So there is no stay for Semoju, there is no stay for Captain Yarugaba. I am not sure why. Uganda Law Society that was referred to was confirmed. The position is clear. And I invite you very respectfully to appreciate that position and to do the right thing and send us where we can settle these questions. They will benefit us here in this case, they will benefit other cases, they will benefit the future. We will have clarity. This is about all of us. Every one of us in this room, every one of us must go home comfortable in the knowledge that we know what the law says. Because again, in this jurisdiction, there is only one person who cannot be subjected to these types of processes. Only the sitting head of state. Everybody else, without exception. I thank you, Honorable Chair, and I thank you, Honorable Members. My land friend wants to close.
Package. So it's misconstruing the context of this petition, rather request for a reference, all the proceedings we have had. So it cuts across. The other thing is about the East African Treaty, the MOU. They made some submission here which is really disturbing, that your ruling is settled it all, that is final. That you are the alpha and omega on interpretation of the Constitution. Is this an appellate court? That is not really the position of the law. We take exception to that. It's outrageous. And it's not also an appeal to the court martial appeal court that this is an attempt to appeal. No. It's very clear, grounded under the constitutional provisions. On the question of the Supreme Court, they said they are decisions of the Supreme Court, the order of state specifically in Kabaziguruka. I want to address you on this. 5th of August, 2021. And the decisions we made reference to of Semuju and Amoni Byarugaba reaffirming the Kabaziguruka position of 2022. So this order is not applicable. And I want us to put it in context, Mr. Chairman. I have a copy here. They are consequential orders that were given. That all files pending before the General Court Martial be transferred to the civil courts. That was the consequential order which was stayed, not the interpretation. And it's the reason he advanced the argument that a decision of the Constitutional Court is in rem, is not in persona. So the consequential order is the one that was stayed. But the Constitutional Court has been consistent that the interpretation about the jurisdiction has not been overturned. If anything, it has been reinforced by the recent Supreme Court decision in the case of Ogwang versus Uganda. If I may just read one aspect of it, it's very, very important and instructive, Mr. Chairman, so that it's the only Supreme Court decision we have, the only one on this. And no misconstruction should be made to say that the Supreme Court has got any other order as far as the jurisdiction is concerned. As they are getting it for me, allow me also refer you to the submission on the applicability of the Firearms Act. Mr. Chairman, the Uju case is very, very clear. It's very, very clear. The General Court Martial's jurisdiction is only limited to trying service offenses specified in the Act must be construed to exclude the laws that are the preserve of civil courts. This has not been set aside. This has not been subjected to any act to handle matters under the Firearms Act. So the East African Treaty, I want to talk about it. The MOU and the East African. Look at the Extradition Act. A fugitive offender is defined. A person having committed an offense, you run away from the jurisdiction. And again, in this particular case, you find the facts, you read the facts. In Tanzania, for example, where these people were repatriated from, there were extradition proceedings, only that they did not wait for the appeal. So this East African Treaty did not in any way purport to outlaw the Extradition Act, or in any way to repeal it. Let me use that word. The treaty did not repeal the Extradition Act. It is still good law, and it must be complied with. So an MOU made under the treaty, which is also subject to question because we have not seen it, cannot be said to be within the parameters of the extradition law. Now, to emphasize the other point, Mr. Chairman, the Army courts as a parallel judicial framework, distinct and juxtaposed against the courts of judicature. It appears to have been contemplated that the UPDF courts were better placed to address the discipline issues within the rank and file of the armed soldiers, and better able to hand out penal sanctions, that hopefully deter further offending. It is through these structures that UPDF soldiers are made accountable. And they concluded by indicating that the Constitution of the Republic of Uganda, which gives Parliament authority to make such laws as provided for under the relevant provisions, deemed it necessary to create a disciplinary court. They emphasize a disciplinary court for the members, the rank and file of the UPDF and members of the UPDF. So this reinforces the position given by the Constitutional Court that the jurisdiction of this honorable court is restricted to those matters which are within the UPDF Act and not any other law. That is the latest decision in Ogwang. Now, finally, the issue of this issue of procedure, the procedure to follow here is very, very clear. Once you move court, for the questions are framed. So we are at a stage of raising these matters for purposes of framing the questions. And this is important. So I don't know how else they wanted this to be done. And this has been the practice all through, that you raise the questions, you raise issues, and then the questions are framed. So they can't fault us on the procedure we have adopted. Allow me to invite the Council Fred to add one to
my colleague, Colonel Raphael, I hope that's the correct rank, did make reference to similar provisions in the Penal Code and the Act regarding terrorism. I just wish to remind him, Mr. Chairman, that none of the offenses on the charge sheet and the amended charge sheet for that matter are brought under the Penal Code or the Act regarding terrorism. So that attempt to juxtapose the two cannot really hold. The other one, he did refer to the appointment of the lady and gentlemen officers of this court and said that they are also appointed by the Fountain of Honor. It is correct. But just to remind the court that when the judges and justices are being appointed, because they do perform a function of determining rights and obligations, including determining whether someone should leave or not, there is an extended process which starts right from running adverts in the newspapers, whereby the public participates. Mr. Chairman, we are not aware of any such similar process of an advert regarding the membership of the court-martial. We are also not aware that the most junior and least officer of the Uganda People's Defense Forces perhaps engages in the process that appointed the ladies and gentlemen officers before us. We want to assume that that is at the pleasure of the Fountain of Honor, perhaps seated in communion with the members of the High Command. And that is why, as my learned friend alluded to, that Regulation 69 envisaged the good manners that you revert to your appointing officers. The challenge there is, Mr. Chairman, is that it wouldn't be about the budgeting or the logistics, as our friend tried to say. It actually says you refer to a point of law. Mr. Chairman, matters regarding life and death are matters of law because the Constitution dictates that one shall only be deprived of life by a decision of a court of law. So my submission is that by removing that function and causing you to make reference to a body which is not here to hear the evidence, to determine, to see the demeanor, to see the veracity of evidence, is to undermine the impartiality. And to that extent, I will add that while my learned colleague gracefully and passionately and professionally referred to what he was told by Mr. Kalibala, I am alive to the fact that he did not teach him that one. But it's over time, so perhaps there is a slip of mind. Mr. Chairman, the other one was in regard to the MOU. Mr. Lukwago, Counsel, my senior colleague, did refer to the fact that we have not seen the MOU. It is not, even where we don't have a hard copy, perhaps Counsel should have been gracious to say it is dated today, it was signed here, and signed by these people. Because the Constitution, Mr. Chairman, in Article 123, reads, the President or a person authorized by the President may make treaties, conventions, agreements, and other arrangements between Uganda and any other country, or between Uganda and any other international organization or body in respect to any matter. The second article is that Parliament shall make laws to govern ratification of treaties, conventions, agreements, and other arrangements made under Clause 1. It means that an agreement, which would be an MOU, which has not been ratified, cannot be or operate as a law, as our colleague tried to point out. It was therefore, my Lord, Mr. Chairman, Section 4 of the Treaty of the Act which deals with ratification of treaties says that all treaties ratified by Cabinet shall be laid before Parliament as soon as possible. So to the extent that the procedure commanded by the Constitution was followed, our colleague shouldn't have been referring to an MOU. They should have been referring to an act which was laid before Parliament, which arose from a ratified MOU. So to the extent that we are looking at an agreement, Mr. Chairman, I don't want to assume that my colleague would agree that as it happened to the accused persons, A2 and A3, that if that fate befell him in the General Court Martial in Kakamega in Nairobi, he would argue that I am here properly because of an MOU I haven't seen. So we request that, again, the right thing is done. We cannot, based on an agreement, to determine rights and movement of people, as Article 123 commands. Lastly, Mr. Chairman, is the prosecution team, ably led by Colonel Raphael, did, in their view, read the questions we proposed and the provisions of the law, and in their view, found that there was nothing to interpret. Mr. Chairman, the points we are making is that the interpretation we are seeking is not the meaning of the words in the statute. That's not the interpretation under Article 137, 5B. The spirit of that article is that it envisages a state of affairs, such as now, which could be an act as action or a law, but which must be put into perspective or juxtaposed with the supreme law, which is the Constitution, to see if it complies with the basic requirements in the Constitution. So it is correct that when we read those sections, we understand what they say. We are only saying that to the extent that we understand them the same way as they do, those brought so or should be brought within the perspective of the Constitution to determine whether they do not contravene the rights of the accused persons. It's not the ordinary meaning. So we do request. And I have seen, Mr. Chairman, that our colleagues do not quite disagree with the way those questions were framed. As my colleagues have said, that is what was expected, and that's what the law envisages. As my colleague read the rules, that once the questions have been raised, the role of the court is to frame those issues and forward them in the manner provided by the annexure, 8 copies. To the extent that they don't disagree with the issues as framed, our request is that the necessary result should follow, that the questions as framed, which they appreciate, be forwarded to the higher court for interpretation, just so that when we come here, we don't bog this court down with objections, because then everything shall be in the clear perspective. We thank you for listening to us, Mr. Chair.
To rule on all issues raised on both sides. The Republic of Uganda, Uganda People's Defense Forces, and the General Court Martial holding at Making a criminal case number UPDF/GCM/040 of 2024. Uganda versus A1RO 127443, Captain Dennis Ora, A2ROV 0098, Colonel Dr.Kiiza Besigye, and A3 Hajj Obeid Rutale. A ruling of the court on application for a constitutional reference. This court delivered a ruling this morning about the objection by Colonel retired Dr. Kiiza Besigye to be tried by this court. The objection was dismissed, but immediately thereafter, the defense team raised an issue that they thought requires a reference to the Constitutional Court. The following are the issues raised. 1, whether or not the accused enjoys a right to a fair hearing before this court. 2, that Section 128F of the UPDF Act is not clear. 3, that this court is not independent and impartial. 4, that this court has no jurisdiction to try civilians. 5, that Regulation 63(2) of the Rules of Procedure makes this court not independent. 6, that Regulation 69(2) of the Rules of Procedure makes this court not independent. 7, that there is a question of freedom from discrimination in line with Article 21 of the Constitution. 8, that this court has no jurisdiction over offenses of unlawful possession of firearms under the Firearms Act. Counsel for the accused made lengthy submissions and cited to this court a number of authorities to support their arguments, and pray that this court be pleased to allow the application and make a reference under Article 137 of the Constitution. In reply, counsel for the state opposed the application and submitted that some of the issues raised were determined by the Court of Appeal, which also sits as a constitutional court, and cannot be referred to the same court because the state appealed to the Supreme Court. Counsel further submitted that there are other sections in different enactments which gives court jurisdiction for offenses committed outside Uganda, AG, the Penal Code Act, and Anti-Terrorism Act, so UPDF Act is not unique. Council also cited cases to support the arguments and submitted that since there is an order for stay of execution in the Kabazuguruka case, that is why this court maintains hearing of the cases under section 117 G and H of the UPDF Act. On the regulations 63.2 and 69 of the UPDF regulations, Council submitted that the judge advocate under regulation 63.2 advises court, and where court finds otherwise, they have to give reasons in writing. For regulation 69, that this court seeks guidance from appointing authority on matters of law, Council submitted that it does not happen. In rejoinder, Council for the accused retaliated earlier prayers that this court allows the reference. This court, after listening to the submissions of both counsels, considered the relevant laws cited and specifically Article 137 of the Constitution has deliberated on this application and finds as follows. 1. That most of the points raised have been decided upon by Court of Appeal, which also sits as a constitutional court, but the state appealed to the Supreme Court. 2. That the alleged defect in a charge sheet is a matter that can be resolved through an appeal to the Court Martial Appeal Court. 3. That Regulation 69 is an old regulation which has never been applied because it is not in conformity with the UPDF Act and the Constitution. 4. That the reading of Article 137.5 is that A and B have to be read together and not in isolation. 5. That the word may in Article 137.5a gives this court the authority to give its opinion whether the questions advanced involves a substantial question of law, and where a party to the proceedings requests for interpretation, the court has to agree or disagree whether to make a reference or not. In the result, this court finds that since most questions raised were decided upon the Court of Appeal, which also sits as a constitutional court, and the matter is on appeal, especially in the Kabazuguruka case, this court declines to make a reference as prayed by counsel for the accused. This court will continue hearing the cases following the order of stay that was given by the Supreme Court, and the application is hereby declined. The accused should take plea. We sorrow done at Makindi this 14th day of Jan 2025 under my hand and seal of this court. Yesterday we were on count 1.
Mr. Chairman, we have a prayer. Mr. Chairman, we have a
Council
prayer.
let us proceed.
We
You
are
talk after
proceeding. We are proceeding under the law, Mr. Chairman. We have instructions under the UPDF Act, Section 225, to appeal that particular ruling you have just delivered, subject to an appeal, Mr. Chairman. And this particular provision, Mr. Chairman, provides that a party to the proceedings of a unit disciplinary committee or court martial, other than a field court martial, who is not satisfied with this decision, shall have the right to appeal to an appellate court on any or all of the following matters. A, the legality or propriety of any or all of them. A, the legality or propriety of any or all the findings.
So the accused persons are briefed by your decision on this matter. And under this particular provision, they are desirous of appealing to the direct court within the framework of the UPDF Act. So we pray that you be permitted to proceed.
No, Council Kwagu, I'm not permitting you this time. Since morning, we have talked about almost all laws, and we have been treating on the same laws. Let's finish this process of pre-taking, and others will follow. Yesterday, we had done with Captain Ora on count 1, and this issue came when Colonel retired Dr. Kiiza Besigye was supposed to take plea, and now to Colonel retired Dr. Kiiza Besigye. On count 1, as you heard yesterday, do you accept or you don't accept?
Mr. Chairman, do I have the right to appeal the ruling that you have just made, or I don't?
I think,
You
sir,
can guide on that.
the ruling, the appeal is not on the ruling. So let us proceed.
But
Mr. Chairman,
then now what are you appealing on?
we want to refer you to that section to 225 that a party to the proceedings of a unit, disciplinary committee or court martial other than field court martial who is not satisfied with this decision shall have the right to appeal on appellate court on any of all the following matters. 1, the legality or propriety of any or all the findings. The legality of the whole or part of the sentence, severity or leniency. It doesn't say that it has to be the final findings. So we are saying that this section gives our clients the right, automatic right, which is not debatable because it uses the word shall. If the framers did not want people to appeal at any stage of the trial, they would say so and say that you can only appeal on the final orders. That is not the wording. So we would want to ask for copies of proceedings and certified copies of proceedings and ruling to enable us to appeal.
Let us proceed with pre-taking. Your appeal on the final decision of the court. I'm the one interpreting the A, which is relying on.
No, listen, I don't know which justice you are talking about because it is for both sides, for us all. Taking plea does not mean that the case is concluded. In fact, it is almost as if it has not started. So taking a plea does not mean that the case is concluded, and I'm not allowing anybody to submit until we first finish this process. So Colonel retired Dr. Kiiza Besigye, once again,
Mr. Chairman,
do you accept or do you not accept?
I decline to take the plea.
A plea of not guilty entered.
That is the rule.
Haji Obedia Rotary, have you heard and understood the charge read to you on count 1?
decline as my colleague.
So a plea of not guilty entered. On count 2, statement of offense, treachery, contrary to section 127D of the UPDF Act, cap 330, particulars of offense. Captain Dennis Ora, Colonel retired Dr. Kiiza Besigye and Haj Obeid retired between February 2023 and November 2024, having vital information regarding meetings to solicit for logistical support with the intent to prejudice the security of the defense forces, consciously withheld the said vital information from the proper authorities. So, Captain Dennis Ora, have you had understood the charge read to you on count 2?
I have heard and understood.
Come on.
I have heard and have understood.
Do you accept or you don't accept?
No, I don't accept.
A plea of not guilty entered on count 2. Colonel retired Dr. Kiiza Besigye, have you had understood the charge read to you on count 2?
I decline as before.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count 2?
I also decline as before.
A plea of not guilty entered. Statement of offense on count 3, an unlawful possession of firearms contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel retired Dr. Kiiza Besigye and Haj Obeid Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, we are found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily a monopoly of the defense forces. Colonel retired Dr. Kiiza Besigye, have you had understood the charge read to you on count 3?
Yes, and I decline as before.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count 3?
Yes, but I decline.
A plea of not guilty entered. Statement of offense on count 4, an unlawful possession of firearms contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel retired Dr. Kiiza Besigye and Haj Obeid Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of a pistol model HB 1015 1953, which is ordinarily a monopoly of the defense forces. So, Colonel retired Dr. Kiiza Besigye, have you had understood the charge read to you on count 4?
I do, and I decline.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count 4?
Yes, and I decline.
A plea of not guilty entered. A statement of offense on count 5, an unlawful possession of ammunition contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel retired Dr. Kiiza Besigye and Haj Obeid Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of live ammunition, which is ordinarily a monopoly of the defense forces. So, Colonel retired Dr. Kiiza Besigye, have you had understood the charge read to you on count 5?
As before.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count 5?
Yes, and I decline.
A plea of not guilty entered. State.
The case be adjourned to 3rd of February for further mention, and the chosen persons be committed to their respective detention centers. 3rd February.
Mr. Chairman, with your permission. Thank you. And, 2 requests or applications. The first one is in respect to section 225, which my colleagues alluded to. And I'm raising in light of the advice from the JA. The JA took the view that the appeal or the right to appeal should only be exercised at the final stage, as I understood him. I hope I'm not misquoting him. Mr. Chairman, the reading of section 225, if we read it a little slow, it says, a party to proceedings of a unit disciplinary committee or court martial other than a field court martial who is not satisfied with its decision shall have a right to appeal to an appellate court on any or all of the following matters. Mr. Chairman, 2251A says the legality or propriety of all or any findings, and B, the legality of the whole or part of the sentence, and C, the severity or leniency of the sentence. Because this is a court and the matter before this court is of a criminal nature, Mr. Chairman, the finality or the final decision would come with a sentence or an acquittal. And perhaps that is where subsection 1, paragraphs B and C apply. Subsection 1, paragraph A does not apply to a sentence, but applies to the legality of all or any finding. Mr. Chairman, a decision in this case is a finding. We want to distinguish it from a judgment, which, even though is a finding, is not a final finding. So in this case, there was an objection raised regarding whether or not the accused persons, A2 and 3, should plea. They exercised their right to raise an objection. The objection, as we have heard from the ruling handed down by the court, has been declined or has been dismissed. And that, in our view, is a finding and also a decision. It's not a decision in the context of a sentence so that A and B of subsection 1 can apply. It is a finding regarding the objections raised, 1, and also the questions for a rephrase. So it is our request that, unlike the advice of the judge of the JA, the right to appeal envisaged in section 2251A and B is not at the end of proceedings. It is in respect to the legality or propriety of any finding, including the finding which the court has just handed down. So we do pray that the court permits that the accused person exercises their right to take the decision regarding the application for reference to the higher court. 2, Mr. Chairman, is that in exercising their right to appeal, and as the sections envisage, in sections 227, is section 227(1), 2, and 3 requires the filing of a notice of appeal and also a memorandum. The memorandum can only be produced because the memorandum states the grounds of appeal. We can only fine-tune them when we have obtained a record of the proceedings of what transpired in the submissions yesterday and today. The state has asked for up to 3rd of February. Today is the 14th. We have 17 days to end January, plus 3 is 20. We request the disciplined force to, in the interests of the accused persons, to use these days to prepare a typed record of appeal, which can be availed to counsel, record of proceedings, which can be availed to counsel, such that they can pursue the remedy available under section 225, which is the right to appeal. Mr. Chairman, in the other courts, there's a distinction, or in the laws setting up the other courts, there's a distinction where a right of appeal is granted as of right, and where a right of appeal requires the permission of the court. In this case, it says that the accused person who is a party to proceedings, it could be the state or the accused person, has a right to appeal. That right, therefore, is not based on the permission of the court. So we are not seeking leave of court to appeal. We are advising the court that the accused person has got the right to appeal, and they are exercising that right, and they are therefore asking to be supported as the law envisages, so that they have a copy of the record of proceedings, prepare their grounds of appeal in the memorandum. We also request that the court avails us a ruling, one which has been delivered a few minutes ago, and Mr. Chairman, you made an order that we availed a copy of the ruling in light of the objections which were availed today. The registry state have not done so. They are not yet, because the order made by the chairman was lawful, they are not yet committing a service offense of disobeying lawful orders. So we hope that they'll oblige, because the ruling has been delivered, it has been signed, and perhaps that in your presence, they will do at least that one, of giving us the copies of the rulings which are ready. Otherwise, we are likely to see our land friend Colonel Raphael on the 3rd of February, when we are lodging our application for contempt of your orders, Mr. Chairman. We request.
That one has no problem, and even the rulings that we have made have no problem. Maybe on the matter of Row JA can guide us.
They understood no problem to mean give them, or they mean the same thing. But we ask, Mr. Chairman, that the court commands that please hand over those rulings now, because they are ready. Yes.
Pronounce yourselves, please.
I think, sir, let me clarify on those issues. The question of the record of proceedings, the ruling you are talking about, the registry falls under my office. As you can see, we have worked throughout the whole day. There is no way you are going to force the registrar to hand over the ruling now. You can come for it tomorrow, but you cannot say I want it now. Secondly, the question about appealing and the record of proceedings, I advised this court that a ruling, you appeal against a final decision of court. And therefore, you cannot try to turn out words to convince the chairman. When I advised the court, we went into plea taking, and we have finished. So the next time is adjourning the next date, and any matter arising, we shall take it from there. That is it, sir. Otherwise, whatever they are seeking, I think we are being off track. We need a date for the next hearing.
Mr. Chairman, a very brief rejoinder.
No rejoinder. There is no rejoinder. For me, I am mandated to advise on the court, and when I address the court, it is not me between me and the state or whatever. No, that is my role. So, sir,
we also, with respect, have a role to persuade the court not to take the advice, especially when it's deliberately misleading.
Not
So
when I have talked.
Allow us. No, you can't. What
Okay.
is the use of having a panel?
Ceasefire Council, Senior Counsel, Karua. We are adjourning this case, and if there is any matter, will be raised on this adjournment. And Captain Dennis Ora and Colonel Dr. Retired and Haj, your case is adjourned up to 3rd Feb 2024 for further mention.
Are there investigations going on?
What?
Are there investigations going on? They just say, are there investigations? And who is conducting the investigation?
Council, that's what I have said. On the next adjournment, please.